Baby boy Hunter Biden making the unusual public appearance, at least appearance of sorts, on Moby's podcast.
That's a entertainer, right? Singer, Moby?
Yeah, this just in. Moby
I know,
is
but
a
I'm
washed-up singer. He
Right. I didn't know
he was eulogized by Eminem 15 years ago. You don't know me, you're too old, let go, it's over. Nobody listens to techno. Moby. Now you're relegated to flacking for Hunter Biden?
Well, you got the get of a lifetime, you know?
They're trying to kill him. You people, you right-wing extremists, you're trying to kill baby boy Hunter.
They are trying to, in their most illegitimate way, but rational way, they're trying to destroy a presidency. And so it's not about me. In their most base way, what they're trying to do is they're trying to kill me, knowing that it will be a pain greater than my father could be able to handle.
What a smug, you know what?
Right.
Your dad didn't do the 1.5 million in crack and all that, prostitutes. You did that.
Abby Lowell is baby boy Hunter's attorney. He was on Morning Joe to pitch his wares, continue to try to advance the narrative that Hunter Biden is being maltreated because his last name is Biden. He's being treated unfairly. He's not getting any benefits. He's being treated unfairly because his last name is Biden. That's the line.
This was a complete surprise to us, notwithstanding we had been in contact with him. Indeed, I think about a week ago, I called the U.S. Attorney's Office for a status check so that I could come in and talk to them if they had any idea that they wanted to bring any additional charges after the gun charges. And at the time of that telephone conversation, they said, no, you already had that meeting. Well, that was based on their investigation years ago. So I said, I want a new meeting. And what they said was, well, we don't know we can do it. I wrote a letter both to David Weiss and copied the Attorney General saying, if there's any new evidence, then we should come in and address it. If there's no new evidence, then how can you justify anything other than what you did in June? And their response was first silence and then the indictment without any communication back to me. You know, again, if I've done this work, I am in the defense bar. That's not the way it works. Prosecutors engage with defense attorneys to discuss the investigation and the possible charges. It's just yet another way that Hunter's been treated differently than others in similar circumstances would be treated. It's because he is the son of the president who's named Biden. The Republicans and anybody else that's been investigating on the right-wing media, for example, have tried and tried to say that President Biden has done something wrong. They can't find a shred of evidence because he hasn't. And yet they want this to be an issue. And what they've successfully done, because they go out on the airwaves and people don't understand the difference between truth and misinformation, is basically saying, okay, I can't get the president, so I'll besmirch his son in a way to suggest that there's something going on between the two of them. That's why it is because his last name is Biden, because of his proximity to his dad, who has been a supportive father to his son through all the best and worst parts of Hunter's life.
For response to Counselor Lowell, we're pleased to have Counselor McCarthy, Andy McCarthy, former Chief Assistant U.S. Attorney, Southern District of New York, Manhattan, contributing editor at National Review, author of the bestseller Ball of Collusion, The Plot to Rig an Election and Destroy a Presidency. Andy, thanks for joining us. Appreciate it. When will this witch hunt against Hunter Biden stop?
Let me get my violin out, right? So, you know, look, Abby's a good lawyer, but you have to understand he's not like working for the truth or, you know, for like some committee that's trying to get to the bottom of it, or even a political committee that's not trying to, you know, whatever. He works for Hunter Biden. His job is to spin everything. You know, he's not like a prosecutor who has an obligation not to misstate facts. I get that prosecutors don't fulfill that obligation all the time, but it's a different gig than being a defense lawyer, where your job is not to tell the truth. Your job is to put the government to its burden of proof. So obviously he's going to say whatever he says in a way that's best geared toward making people sympathetic to his paying client. But the fact of the matter is, if this defendant's name wasn't Biden, he had been prosecuted in the normal course probably by 2019, maybe 2020, and he would probably have been looking at a lot more than tax and gun charges. There would have been a possibility of going after him on foreign agent registration violations, money laundering, potentially bribery. Because his name is Biden and he's being investigated by the Biden Justice Department, they brought in a prosecutor who dragged his feet, not so much for Hunter's benefit, but what the foot dragging on this accomplished was a lot of the most egregious, apparently criminal behavior that happened here happened between 2014 and 2016 when Joe Biden was vice president. That stuff will never be prosecuted now because David Weiss, the prosecutor on this case, never filed charges and never addressed the fact that the statute of limitations was lapsing as he was delaying, because that was the objective. So it's now almost 2014. The statute of limitations on most federal crimes is 5 years. On most tax crimes, or the relevant tax crimes, it can be 6 years. But, at this point, we're like 8 years after some of the worst behavior occurred. So they've made sure that can't be prosecuted. And this idea that, he hasn't been, the Biden defense camp hasn't been consulted by the prosecutors. When they tried this sweetheart plea deal in July, I was astonished at the fact that it was very clear Hunter's lawyers had actually drafted a lot of what was in the plea arrangement, particularly the statement of facts, or what they called facts, that the government signed off on. The usual practice in federal law enforcement is the government writes the plea agreement, and the government writes any diversion agreement, and the government drafts the statement of facts. Here, the solicitude toward Hunter was unbelievable, just as unbelievable as the fact that they tried to trade this very significant tax case away on 2 puny misdemeanor counts, which no one not named Biden would ever get that kind of treatment. And even worse, they tried to make the gun case, which involved, a 10-year felony, completely disappear with no prosecution at all under a diversion agreement in circumstances where diverting for that particular offense under the circumstances of it is against Justice Department rules, such that when the court asked a few simple questions about it, the deal collapsed. Not because the judge was asking hard questions, just asking like normal questions about what's the scope of the agreement. They wouldn't even fess up to that because what they were trying to do was give this guy a complete pass.
Well, do you think he'll spend any time in jail? I know he faces up to 17 years.
Well, if he was my son and I was the president, he would not spend a day in jail. I mean, if I had the pardon power, and look, you shouldn't do it. And a president who pardons his son under these circumstances, or probably under most circumstances, should resign because it's an abuse of power. But I wouldn't let my sons get sent to the penitentiary.
Well, especially if he was filling my pockets, which appears to be the case, despite Abby Lowell's and Jamie Raskin and the Dems line that there's no evidence that links Joe Biden. The evidence continues to mount with each passing pronouncement from Jim Comer at the House Oversight Committee. Now, yes, there's some additional dot connecting that needs to be done because there's some additional questions that need to be answered, prompted by the evidence that has been uncovered. But this whole line that there's no evidence, frankly, the public isn't buying it. The public didn't buy the Russian collusion hoax, and they're not buying that Joe Biden had nothing to do with his son's multi-million-dollar business.
Yeah, Dan, that's a great point, and I think it's one that people should kind of take in this sense. I keep getting asked, so these guys are going to completely get away with it? Like nothing's going to happen to them? And my response to that is, look at what's already happened to them. Comer's been running this investigation for 10 months. What is the public appraisal of President Biden over the last 10 months? It's not it's not solely because of this investigation, but it's had an enormous impact on the public perception of Biden. It's part of the reason his numbers are cratering. It's part of the reason they're in a hot panic now over whether he can be reelected.
I wanted to switch over and get your reaction to what the special counsel prosecuting Donald Trump did yesterday and seeking to leapfrog the appellate court and get a ruling from the United States Supreme Court on Trump's immunity claims as it pertains to the charges against him relating to January 6th. What is Jack Smith trying to do there, and what would your adjudication of his petition be?
Well, I think the important thing here, this is about the immunity claim that Trump makes, that he is immune from criminal prosecution for actions that arise out of his constitutional duties as president. That's his claim, and the Supreme Court has never ruled on it. They've ruled that a president has immunity from civil lawsuits arising out of his official duties, but they've never ruled on the criminal prosecution question, although they have suggested that they wouldn't give the same protection from criminal prosecution as from civil. So that's the issue. But the importance of it is just as important as the substance of it is the timing of it. The preference in federal law is that you don't get pretrial appeals. The idea is that you're supposed to try the whole case in front of the lower court, the district court, the trial court, and then the case goes up on appeal to the circuit court and then finally to the Supreme Court. But there are some issues, like double jeopardy and immunity, which go to the question of whether it's appropriate to try the person in the first place. And with respect to those issues, you do get pretrial appeal. And the reason that's important here is Trump's strategy is delay. He wants to get the case put off beyond Election Day, because if he wins the election and there's a new Republican Justice Department, he'll get them to dismiss the case, and then he won't have to face it. So the Democrats are in a lot of haste to get the case tried. For one thing, they're worried that if Trump wins, he'll never be, tried for these terrible crimes that he committed that are hard to even explain to people. But the other thing is they have always wanted this arrangement so that they could indict in a way that galvanized the Republican base and has helped Trump in the primary process. But then they've wanted to switch to trials where they could get like the icky information about Trump out in the public domain. And they figured, and have always figured, that that would help them with the general election, particularly if they get him convicted. So they're in a hot panic to get him convicted. What Smith is worried about is losing his March 4th trial date, because if Trump gets to appeal to the D.C. Circuit and they take their time, and then he gets to appeal to the Supreme Court, the March 4th date won't hold. And the later it gets, the harder it is to schedule a trial right before Election Day, because the Justice Department purports to follow this rule that they try not to do things that are going to influence elections. So that's the state of play. I think Smith, to me, he's making a mistake, because I think he's much more likely to win in the D.C. Circuit, and then he could probably convince the Supreme Court not to take the case, because the Supreme Court could always tell Trump, if Trump was the one doing the appealing, Supreme Court could always tell Trump, we're going to side with the D.C. Circuit for now, and if after you have a trial and there's an appeals process, you want to come back to us and raise the immunity, we'll hear it then. The Supreme Court can do that, and that would keep them out of the politics of 2024. But instead, what Smith has done is he's trying to cut the D.C. Circuit out, which I think is foolish, because now he'll be in the Supreme Court without what he would otherwise have had, which is probably an opinion that he likes from the D.C. Circuit. And in the Supreme Court, he could lose.
Well,
I don't think he's going to lose, but I think he could lose.
Well, I mean, the other thing, though, too, the Supreme Court justices don't, they're not, sealed away in hyperbaric chambers. They know what's going on, and they see what Jack Smith is attempting to do, which you're describing, which is he has a political agenda that is, for him, that dovetails with his legal strategy. But ultimately, there's a heavy dose of politics influencing this petition that he has filed with the Supreme Court, and I would think that a number of justices would recoil at that.
Yeah, I think that's exactly right. I mean, I think this is very offensive to my mind because prosecutors are not supposed to be concerned about pardons. They're not supposed to be concerned about election dates. They're not supposed to be concerned about what the outcome of the election might do. Their only job, Smith's only job, is to represent the United States and present its case the best he can whenever the trial gets scheduled to prove the case beyond a reasonable doubt. It's not for him to worry about whether Trump might pardon himself or Biden might pardon him if the politics spun that way, or you don't worry about that. That's not your job. That's politics. You're supposed to stay out of politics. So the court is going to understand that he's gotten himself in politics. And the other thing, Dan, I think that the court might be offended by, and I've thought all along Trump needed to do whatever he could to get this case in front of the Supreme Court, and now Smith is doing it for him. But, you know, these four charges that he's brought are very dicey interpretations of federal law, including some Supreme Court precedents. I mean, the Supreme Court just in the last year held that a fraud case in federal law has to be a financial crime, and that fraud is not a concept that you can use to impose somebody's idea of what good government is like. I think he's going to have a very hard time with the fraud on the government charge, which is the main charge in this case. I don't think the Supreme Court's going to like it. And I think he's basically throwing the door open for them to have a look at his indictment, and they may not like his indictment, just like they may not like that he's worried about the politics of the election.
So with respect to Trump's representation, you know, they're making a double jeopardy argument related to the impeachment and that trying him for something that he was impeached upon is double jeopardy. I don't really find that persuasive, but I do find more persuasive what you were just talking about. And so what is the Trump team's strategy? Are they just sort of arguing in the are they making a mistake, strategic mistake?
Yeah. I think the double jeopardy argument's frivolous. Even if Trump had been impeached for exactly what he's being tried for, like the exact same conduct, and he wasn't. The impeachment was called incitement to insurrection. There's no incitement charges in the criminal case. But double jeopardy doesn't create any. Impeachment doesn't create any double jeopardy protection. So the fact that Trump was acquitted in the impeachment trial doesn't give him any double jeopardy protection from a later prosecution. The Constitution explicitly says that the president can be tried later. And the fact that it says if he's convicted, he can be tried later, that doesn't mean that he can't be if he's acquitted. That's not what that provision in the Constitution means. So I think that's a loser of an argument, and if I were they, I would drop it. The argument that I think is profoundly important is this idea of whether a president should be open to prosecution for actions he takes that are within the ambit of his Article II executive powers. The Supreme Court has given the presidents immunity from civil suits precisely because we don't want presidents worried when they're wielding power in the public interest that they might be sued later for their actions. I think, you know, to say that makes sense for civil liability but not criminal liability is not an argument that makes sense to me anymore. It might have made sense at a time when we had a norm against politicized prosecution, but now I think every president, what this case shows is every president is now going to have to worry that an administration of the opposition party, when they come in, they may look at what policy disagreements they had and try to make criminal cases out of them. I think it's a crazy banana republic style of governance, but, you know, it's happening before our eyes.
He is Andy McCarthy, former Chief Assistant U.S. Attorney, Southern District of New York, contributing editor at National Review, author of the bestseller Ball of Collusion, The Plot to Rig an Election and Destroy a Presidency. Andy, thank you as always for your insights. Appreciate it.
Thanks so much.
Thank you. And he joined us on our turnkey.pro answer line.
Connect with Dan and Amy on the AM 560 The Answer mobile app. Just text the word app to 64636 to download the app today.
Hi, everybody. I'm Kathy Lee Gifford, and I've been blessed to have a wonderful career for a lot of years. People still come up to me all the time